Please be advised that this podcast was made for fun and to share the general experiences of two criminal lawyers in Toronto. You must not take anything you hear in this episode as legal advice. Every situation for every person is different, and you should always consult with a lawyer for legal advice specific to you and your circumstances. Hello. Welcome to another episode of Justice Redefined. I'm Sina Shabestary, partner and criminal defense lawyer at Titan Defence LLP. And today's episode is part 2 of criminal appeals with myself, Kabir Sharma, and our guest and appellate lawyer, Mark Halfyard. So how long do appeals take?
Hard to say. I mean, the rules say they should be done in about 6 months, but it's 90 days after the transcripts are produced, which generally takes about 3 months. But in reality, people's schedules, people's workload, clients paying retainers and dealing with the financial side of the practice of law. I would say a typical appeal, something maybe in the length of a 5-day trial. So not something really short, but not multi-week murder trial or something. I would say typically something like that takes between 12 to 15 months to wind its way through to the Court of Appeal. Right. So significantly longer than, one would say the rules would dictate it would be. But I mean, I think the rules were written quite some time ago when, trials were shorter, things were less complicated. Yeah. And unfortunately, it's just, if you want to retain a lawyer who specializes in appeals, there's not a ton of people that do a strictly appellate practice, and a lot of them are doing the same kind of pool of work, right? And we're often quite busy, so our own schedules sometimes lead to things taking a bit longer than they otherwise would.
So Mark, if you're in jail, right, and say that you want to file an appeal, can you bring a bail after you've been sentenced to kind of get bail while you're waiting for your appeal to be heard?
Yeah, you can. It's called bail pending appeal. So as the name says, it's a bail hearing while your appeal winds its way through the court. And most people who were out on bail at trial and have a good appeal should get bail pending appeal. I mean, I don't think the court likes to keep people in jail while they're appealing if there's any way to release them. But you have to show a bunch of things to the court. It's not just like you want to bring an appeal, you get out, right? You have to show that basically you're not a flight risk, that you will attend court or surrender back into jail if you're ordered to by the court. Yeah. You have to show that you're not like a public safety risk. Mm-hmm. And you have to show that your appeal has merit, so that you're not just raising a frivolous appeal. And all of those burdens are on the appellant, and not like at trial, except some circumstances where people have breached their bail. It's the Crown's job to say you should stay in, not your job as the accused to say I should be let out, right? Yeah. Where on appeal, all the burdens are on the person appealing. The court is going to assume the conviction and the jail sentence is valid unless you convince them that there's an exception should be made in your case to release you while your appeal is before the court, right?
I suspect that's probably the easiest when an individual has bail, goes through trial, is convicted, and now obviously after sentence they receive a jail sentence and their bail is revoked or no longer in effect, and then they bring a bail pending appeal. That's when their prospects of success could be higher depending on what you've said. Yeah. What about clients who have spent time in custody awaiting their trial, have a conviction, are sentenced to further jail, let's say, and now they bring an appeal and the appeal is successful and sent back for a retrial? Do those clients typically try and get bail?
Yeah, you can get bail, what's called bail pending new trial. So obviously the circumstances of an accused person may drastically change by the time the trial winds its way, the appeal winds its way through the system. It becomes more difficult when you've been denied bail throughout. So obviously, like people who have bail, like you said, and have been compliant and are applying for bail pending appeal, whether that's before trial or after trial, that track record gets them a lot of traction with the court, because obviously someone who's been out and complied for 2 years while their trial has been winding its way through the provincial courts, they look a lot more likely to get bail on an appeal. If you've been detained and you're trying to do that, then the question becomes, why were you detained? Is there been a change of circumstances? Can you put up a better bail plan? More money on part of your sureties? It is harder where you were detained the whole way through. And even when you win your appeal, many people will have to stay in custody. But sometimes if you're in there that long, you're almost at the end point of your sentence, right? So, I mean, you might be able to make an argument, even though I wasn't, a good candidate perhaps, or didn't have enough surety money or like a bond to put up at the trial. Now that I've only got 2 months left on my sentence, even though this is a serious offense, like the reality is if I don't get bail now, the whole jail sentence may be served or it may be moot, right? So sometimes you can make an argument that even though they may not be the best candidate for release, because they're going to be released in any event in such a short period of time, that they should still qualify for bail. But it's a lot harder if they're detained all the way through, for sure.
To that end, I think, and this is kind of a question from a civilian, not so much a lawyer. I think what people are interested to know about is if an individual doesn't get bail, then they spend time in custody, they get a conviction, they bring an appeal, and then their appeal is successful. Is there anything in the criminal justice system that accounts for the erroneous time that they spent in custody?
Well, you mean in terms of like trying to sue or something after the
fact? Right, like a reparations of some sort,
I mean, that's a difficult question to ask in the abstract. I mean, I think the answer, I think, is it depends. Yeah. I mean, we all know the real serious wrongful conviction cases where there was like maliciousness on the part of the Crown or like incompetence on the part of the police and the Crown to the point where someone has actually suffered a civil wrong as a result. But I mean, if it's a type of case where the judge just got the evidence wrong or something, like it's an honest mistake but a fatal mistake type thing. Like in many cases, most cases I would think are those type of situations. Everyone's trying to do their job properly. It's just the judge made an error in the application of the law or the evidence, and it leads to the Court of Appeal saying it should be redone on a retrial or sometimes even ordering an acquittal on an appeal. Right. But in most of those cases, I would say no. But in some cases, particularly where there's like malfides or like bad conduct on the part of the Crown or the state investigators like the police, there may be situations where people could sue civilly, but that takes place in the, not in the criminal justice sphere. That would be, we would, if a case like that arose, typically on my end, I would be referring them to like a civil lawyer that works in that area, because it's very tricky suing the government, and and there's very tight timelines, and sometimes your amount to recover damages is limited. So you need proper legal advice from a practitioner about if you're going to take that step.
So if there's this is a question I get from my clients quite often. I think I know the answer to this question, but I'll ask you anyways. Say a judge is repeatedly making errors, over and over and over again, and they're constantly getting appealed. Does anything happen to that judge at all?
Well, I don't think, not formally, because judges have what's called security of tenure, so they're independent of the government. They can't really be fired unless they engage in misconduct that rises to the level of like a judicial complaint against them or something. Yeah. And that can be generated internally or externally. So I mean, there could be that very rare scenario, but I mean, I haven't seen that. Okay. I mean, I think what happens more is like soft pressure on judges. Like, I mean, they take it personally, I think. I mean, judges
I've always wondered.
Judges, I think, are people are different. So I'm sure some people are laissez-faire about this, but I think the vast majority of judges, if the Court of Appeal reverses them and tells them they're wrong, they take that to heart and try to fix it the next time. But I guess the answer to your question, the answer is probably no. Like they can't be fired just by making legal errors, but I mean, a regional senior judge could take them off cases or, give them a more administrative role. I don't know if anything like that actually happens. That's just anecdotal.
All like whispers and
anecdotal. But I do know that most judges take being reversed very much to heart, and it's seen as like a slight, like they take it personally and professionally that they made a mistake
on their reputation.
And also like a learning experience too, I guess, right? To like learn from the fact that like hopefully they won't make this type of mistake again. It's kind of like when you appear at both levels of court, like I do a lot of summary conviction appeals, but I also do a lot of Court of Appeal work. Like sometimes I'm appearing in front of judges that I know I've gotten reversed, and it can be an awkward kind of thing as a litigator. Now you're in front of the same judge that you might have 5 years ago got reversed on a case for making a mistake, and now you're asking that judge to reverse another lower court judge. Right. Like, and you always wonder, is this going to be something that's, you know, they hold against you personally as the advocate? But I mean, at the end of the day, like, you know, you doing your job, you got clients, and it's nothing personal. It's just, you're just trying to raise whatever issues professionally you can in good conscience and ethically for your clients, right? So,
since we're on this topic, I just have one more question since we're on this topic. Yeah. So when you appeal a judge's decision, do they get notified that it's being appealed? I've always wondered that.
I think they do, although I've never really formally been told how that occurs. But certainly, I think there's an informal mechanism. I don't know if the Court of Appeal sends them a copy of the notice when it gets filed, and maybe it could be different between regional practices. Like certainly, I think in a small jurisdiction, you know, if you go to Sault Ste. Marie and you're appealing one of like the 10 provincial court judges in that area, or like Orangeville or something where they have a smaller court, they may, I'm sure it's probably just informally they find out they're being appealed.
Maybe over a game of golf.
Yeah. Who knows? Or around the coffee or around the cafeteria table that they often will sit out at the courthouse, right? But I don't know. I can't say 100% that there's a formal mechanism, but I suspect that they do get notified by the Court of Appeal by the notice, because I you know, just from my own kind of anecdotal dealing with people, it sounds like most judges know when they're being appealed.
I think that's a question I'm going to ask a judge.
Yeah.
I think it's totally fair to answer that.
Or the Court of Appeal. Like, I mean, it would be nice to know like a firm answer to that, right?
Because even if you're appearing before the judge and you're appealing them, I just kind of want to know, is this attitude coming because I'm, you know, because they don't like
the other issue that crops up sometimes, and I mean, clients are always obsessed about this, but I generally don't think it has much of an effect. But it's sometimes you file an appeal post-conviction but before sentence, because you're trying to line up a bail pending appeal so that the client doesn't spend much time in jail. So you might file the appeal months ahead of even the sentencing, and the trial court is still a live proceeding going on, and they haven't sentenced the accused. And clients are always like, will the judge find out that, you know, there's an appeal filed? And my advice is it's likely, but I don't know necessarily if that's going to happen. Like, I don't know if it gets lost in someone's inbox or how this actually works on the ground. But clients are very concerned about that most times. But I think most judges are professional enough that they don't let the fact that they're appealed influence the job they have to do in concluding the sentence.
I mean, I wouldn't let it impact me.
For sure.
Right?
Yeah.
And like, you know, I'm like pretty easygoing guy.
You have to believe the same is true of them. I think everybody in this, all the stakeholders.
Very few of them are vindictive people, right?
Exactly.
It's a job.
It's a job. Yeah. And the reality is, I mean, people file appeals all the time. Like the success rate at the Court of Appeal, you know, not to talk myself out of work here, but it's a hard exercise, right? Like I think for defense appeals, anecdotally, statistically, it's somewhere between like 10 and 15%. So for every 10 appeals that get filed, maybe 1 or 2 are successful. So, I mean, we often give opinions to clients in advance of them filing an appeal. So hopefully clients go in knowing this is a good appeal, it's a hard appeal, it's an impossible appeal, and then they decide whether they want to go, right? And some clients you might like, I don't generally turf a client if they want to appeal, even though I tell them that this is, you know, a very, very difficult appeal. Like if there's something to argue, then and they want to argue it, it's either they argue it with a lawyer or they end up on some self-represented list before the court as an inmate appeal fighting about their appeal. And I think the judges would rather at least have a lawyer and to narrow the issues and say what it is. But like the reality is most of them are ultimately unsuccessful, right? I think it would say something bad about our system if like we had a 50% success rate at the Court of Appeal, right? Yeah. But you know, most of them are unsuccessful. So it's hard to win up there, right? Like it's a hard exercise.
Is it the same for the Crown too? Most of their appeals are also unsuccessful? Or
they're kind of about 50-50, but I don't think it's because they have better advocates working for the Crown's office.
Is it because they appeal less?
They appeal less, and
they're very selective.
They're a lot more selective. Yeah,
I see.
Yeah, they're a lot more selective. I know at least from the provincial side, because obviously there's drug appeals that are dealt with the federal Crown, and just for the listeners, and there's 2 separate Crown's offices that could deal with more serious appeals: the provincial Crown and the federal Crown. The provincial Crown, at least, you know, vets it by a number of lawyers at that office to make sure they feel they've got a good case before they're going to file an appeal. But they're not responsible to a client who's looking at, you know, 8 years in jail and says, if you can argue anything, just appeal this, right? So they're often more concerned about like the incremental development of the law in areas that, would concern the crown, right? So there's just less of them. They're more vetted. And I think because of that, their success rate is marginally better, but it's still difficult even for the crown to win an appeal, right?
Yeah. So can you actually talk about that a little bit in terms of, I guess, what we would call vexatious appeal or frivolous, or just the client who is appeal heavy,
Yeah.
Is it basically whoever can pay, or do you make an assessment with respect to the prospects of success?
Yeah. Oh, I in a perfect world, I always want to do an opinion with a client before I even accept the retainer. Now, sometimes that doesn't work because of time constraints and when things have to be filed, and you might have to kind of, go in without knowing the full picture before you have to file an appeal, just because you only have a certain time limit after convictions. It's 30 days in most cases to file an appeal, or sorry, after sentence, not conviction. After sentence, you have 30 days to file the appeal. So, I mean, sometimes just kind of the practical realities require you to launch an appeal before you have the complete picture. But ideally, if clients come soon enough, you want to give them a full opinion. And my philosophy is largely, it's your money. Yeah. I tell them what the odds are. And if there's something to argue, if there's a ground, even if it's a very, very difficult ground, and the client wants to pay me for that service, then I will take their case. But if I review the case for merit and I'm like, I couldn't, make a straight-faced even argument to the Court of Appeal. Like, there is just nothing here. The judge's decision is bulletproof. The evidence was super strong. There's nothing procedurally that there was no procedural flaws in the trial. Like, I just see nothing. Then I'll just refuse to take the retainer, right? And that's why I think the opinion, if you're doing it that way, and I mean, you have clients that, like legal aid opinion appeals all require opinions. Legal aid won't fund an appeal. So if you're doing some legal aid government paid retainer on appeals, they will not accept an appeal unless a lawyer has written a viable letter to legal aid saying there's merit to this, right? With private clients who are paying out of pocket, it's trickier, right? Because some of them are very litigious and they want to appeal even if the odds are, impossible.
Right.
And, there is times where you have to tell a client, like, look, enough's enough. Like, you just can't win this. You could pay me whatever. You're not going to be successful. And I'm not appearing in front of the court and arguing something that is completely bald-faced frivolous, right? Like, I just don't, that affects your reputation as a lawyer too, right? So.
And Mark, for what it's worth, I don't think you're talking yourself out of retainers here, because 10 to 15% is actually a pretty good stat, considering that I think the number of cases that actually make it to trial in Ontario is somewhere around like 5%.
Yeah, for sure. Yeah, most of them ending guilty pleas, right?
Yeah, that's right. So
or withdrawn by the Crown.
Yeah. Yeah.
So I wanted to raise something that's been of interest to me particularly. So when you're talking about, people appealing and what the prospects of success are, et cetera, we touched upon this a little bit with respect to the United States and what their appellate system is like. And even generally before with respect to the juries, and you thought that what we have here is a blessing comparatively. Can you speak to the difference in the appellate system in the United States and Canada, and which do you think is a better system?
Yeah, well, I mean, at first blush, we're both kind of like common law systems. Like, I think the basic structure, although, again, it's hard to comment on the states generally because criminal law is state by state.
Right.
Yeah. Where here it's federally. So at least we're blessed by the fact that whether you're doing a case and it might be different kind of procedural stuff on the ground here, and maybe how it plays out in practice is a little bit different from, New Brunswick to, BC or Newfoundland to Ontario, but it's largely the same criminal system in Ontario, right? Where every state has its own appellate courts and has its own process of doing things. So it's hard to kind of generalize.
Right.
I've never looked qualitatively in terms of like numbers of whether more cases get overturned in the States. The one thing about the U.S. Supreme Court is that they have a lot more of a gatekeeping function on what matters get to the Supreme Court.
Right,
like it's only like constitutional cases or cases, I think, that engage federal law in the States that can like be eligible to get heard by their Supreme Court. So our Supreme Court, will hear any appeal where you've basically exhausted all your appellate remedies in the province. So that could be at first instance, if there's no route of appeal coming from a ruling, you might automatically be able to go to the Supreme Court and ask for them to hear the case. But most of them are like, you've appealed all the way up to the highest court in the province. They've said no, and now you want the Supreme Court to take a different view. So, I mean, in some respects, we have a more robust body of cases that our Supreme Court will hear than perhaps the states, but like state to state in terms of how the individual appeal courts work, that's out of my pay grade. I don't know enough about it to want to comment. I wouldn't want to get it wrong.
And I want to return to this. I want to ask a basic question about the Supreme Court in a minute, but based on my extensive research watching television, it just seems like in the United States, the threshold to even be able to appeal a case in the first instance is extremely high, right? Whereas in here, you can appeal any case you want. Like the higher court will hear it, if I'm not mistaken, unless, there's instances of having to seek leave, etc. But if you can file an appeal and the Court of Appeal will hear it. Am I right in that?
Yeah, you have an appeal as of right for your first level, what we call as of right. So you can file an appeal without anyone saying you can't do it. Doesn't mean you're going to win.
Exactly.
But you can file it.
You can file it. And you can bring the arguments.
Yeah, you can bring the arguments and someone has to hear it ultimately, right? In the States, the only thing that I think with the US, I think their appellate routes seem to be more restrictive from what I see, but they also have a system in many states of post-conviction review, right? Where they will hear new evidence and like sometimes cases, particularly older cold cases, can bring a writ of habeas corpus or like a writ to like reevaluate the case. Right. And they might actually have almost like a second trial review where they're considering new evidence or changes in procedure where we don't really have that process in Canada at all.
We don't have the death penalty.
Yeah, we also don't have the death penalty. Fair enough. Yeah, and I mean, when you're talking capital crimes, it's a whole different... I can't imagine practicing in a capital jurisdiction. Yeah, geez. The stress of that would probably drive all lawyers to drink. They might, again, I think it's really hard to answer because it's state to state, but I think some states might fill that gap with these post-review processes, which we have some type of, you can bring fresh evidence on an appeal, but it's very restrictive. It can't be things that could have existed. You can't just say, I'm unhappy with the way my trial was ran. I would have called 2 more witnesses. Here are those 2 witnesses. Please consider this on my appeal. Yeah. Because if those witnesses were available, they could have just been called. So it's a question of how diligent you were. You're not there. The Court of Appeal is not there to retry the case.
It's not a second kick at the can.
Yeah, it's not a second kick at the can. Yeah, that's the bottom line.
Can you very quickly tell us how a case gets to be heard at the Supreme Court of Canada?
So there's basically 2 routes. Probably the most common route in criminal law is the Court of Appeal the provincial appellate court sits in panels of either 3 or 5 judges, and it's majority rules. Right. They generally try to come to majority consensus, and judges who will write what's called the dissenting or a contradictory opinion. So where 2 judges will agree that the appeal should be dismissed, but one judge will agree the appeal should have been allowed. So you have 2 different opinions, one in the majority and one in what's called the dissent or the contradictory opinion. That if you have a split amongst the provincial appeal court, so in any way, whether you're the winner of that split or the loser of that split, one of the parties is going to have what's called an appeal as of right to the Supreme Court. So the losing party on a dissenting judgment can immediately have the Supreme Court take their appeal, so they can file their appeal, and the Supreme Court has to hear their appeal. Because there was a disagreement below.
I see.
For majority judgments, so where there's no disagreement, all the judges agree that the appeal should be dismissed, then in order to get the Supreme Court to hear the case, you have to actually ask the Supreme Court for special permission, which is called leave to appeal. Right. And you have to write a very detailed in writing application that gets reviewed by a couple judges, or I think panels of 3 or 5 at the Supreme Court review leave applications. And it's only if they feel it has a nationally important issue, an issue that is more important than just the facts of one individual case, but it has some public importance to the whole country, that they generally will agree to take the case up and hear it.
Right.
So for most people, your provincial Court of Appeal is the end of the road for you.
Yeah, I think it's about 97% of cases. It's 3 to 5% of cases get leave, and that's not just restricted to criminal law. So that includes the civil cases in the mix. So like if the Supreme Court, if you file a leave on behalf of a client and the Supreme Court says we're granting leave, it's like pop the champagne bottle, because this might be 2 or 3 times in your career where you're going to have them actually on a non as of right appeal consider the issue to be so strong and so important to the development of the law that they're actually going to take your petition up and hear the case, right?
And statistically, does that cut both ways with respect to who is seeking leave?
I mean, I don't know the number. I mean, the numbers are 3 to 5%, I think, statistically across the board.
Right.
But I don't know within that percentage if that means
the Crown gets it more,
are getting more cracks at it or more defense appeals. I don't think the Supreme Court keeps very good statistics. Most of this is available on their website, but I don't know. I don't know the answer to that question.
And given the beautiful explanation that you just provided, the question that I wanted to ask was, what do you think is the sentiment behind having more than one judge sit on a panel of judges in all appellate courts, but for summary conviction appeals?
Yeah, well, I think it's very important, right? Because you're arguing a case to not just one person, and everyone has different predilections, believes in different issues. Particularly when you're asking them to expand the scope of the law or interpret a law, it's helpful to have varying perspective. And some court of appeal judges come from an enmeshed practice in criminal law, so they know criminal law really well. They bring a certain lens to the table, just like we would bring that lens probably because that's what we practice in.
Right.
And then other judges have, civil background and haven't done much criminal law, probably as a practice, maybe experienced some when they were a judge before they got elevated to the court of appeal, or maybe come from private practice and have no criminal law experience, but they still have a certain perspective on things that, creates an interesting dynamic. Like I'd be in form of more judges, not less. The problem is it becomes a lot more daunting and difficult to prepare. If you appear before the Supreme Court and you're in front of 9 judges, you just don't really know where the questions may come from because you're not just having a conversation about the state of the law or an argument about the state of the law with one smart legal mind. You're dealing with 9 or 4 or 5 or 3 or whatever the composition is, right? So it makes it for a different dynamic.
It's in furtherance of effectively like a vibrant democracy, so to speak, because you have the numbers, right?
Yeah, and the numbers, and I think even like as you get to the Supreme Court more often than below, you often get public interest groups intervening. Yeah. So you get a lot of like public interveners, adding to the discourse that may take the issue in directions even that the parties aren't advancing, right? So, I mean, I think that is really important. Unfortunately, the Supreme Court's been kind of like narrowing the role of interveners in a number of judgments. But, it's just when you're making decisions at that level on such an important topic, to me, again, it's more the merrier. Like they should be considering all sides. And sometimes it might be a small interest group that has a really important point to be about how the nuts and bolts of, a case might ultimately play out on the ground. And that maybe the parties who are just arguing these, abstract legal principles may not realize, if we say this, that's going to be very disadvantaged to this group, or that's going to make this very challenging to be litigated, or it's going to cost a lot, or, that kind of nuts and bolts stuff that, you might not get at the top kind of academic level of what the law should be, right?
Mark, do you or have you rather taken any appeals pro bono where you thought personally that there was a wrongful conviction?
Yeah, I have. I mean, I worked for a while with Innocence Canada doing like post-conviction review in that regard. That's more like ministerial, like outside after they've exhausted their appeal routes. But yeah, we occasionally take pro bono cases. I did a case on drug log recognition records pro bono because I just thought that this is when they brought in drug recognition. So after marijuana was legalized, about whether they should disclose the logs of the so-called drug experts.
Oh yeah, I remember that issue.
Stippo's the name of the case, and that I did that case pro bono to the Court of Appeal because it was like of interest to people that practice in impaired driving law, which I had a particular interest, and it was also interest, like I think generally to criminal lawyers. That was in response to a Crown-initiated appeal as well, right? So in that particular case, like sometimes clients just don't have the resources to continue litigation, and some issues are just important enough that you take it on pro bono just to help, just for the development of the law or for whatever reason.
part of the reason, actually, in large part, that Kabir and I started this podcast is because, as Kabir has said, we think law in general, but especially the criminal justice system as well, it's something that, you go to school for 10 years and it's this like complex and convoluted thing that's even difficult for lawyers to grasp and understand. Obviously, in the criminal justice system, we have or we try to have a system where an individual who is self-represented has to be able to easily navigate the system, especially given the large access to justice gap where someone is not poor enough to qualify for legal aid and they have no disposable income to be able to retain a lawyer privately. Do you think that system is reasonable in extending or making available or accessible appellate really for a self-represented individual to do their own appeal?
Well, I mean, to be honest, I'm biased here because I chair the program that assists self-represented people before the Court of Appeals. So we have a system in Ontario that we're hoping to maybe export to other provinces in the future, where very experienced appellate lawyers volunteer their time as duty counsel to assist self-represented people and to assist the court to sort out those problems. It's called the Inmate Appeal Program. And at current, we have a roster of about 40 appellate lawyers that volunteer their time a couple times a year for special sittings of the Court of Appeal, which are called inmate sittings. And they're not there, our duty counsel are not there to be the person's lawyer, but we get a part of the record that the court orders to assist self-represented, and we generally get them a couple weeks, although in a perfect world, a couple weeks. Sometimes things come in dribs and drabs with self-represented accused, but in a perfect world, we get the files a couple weeks, or whoever's volunteering that inmate sittings to review the files. And sometimes we see things that are very viable grounds of appeal, and we've won as a program a number of successful appeals, even precedent-setting appeals, where a person just fell through the cracks because they didn't make enough money. They made too much money to qualify for legal aid, but not enough money to properly finance a complicated piece of litigation through the court. So, again, I'm a bit biased in this regard, but I think bar none, the Court of Appeal has the best system for representing. You might end up in a situation where, as a self-represented person, you get a more experienced lawyer doing your self-represented appeal than you might hire independently through legal aid or through private retainer, because it's just whoever is there that day is going to vet the files and come up with the arguments.
So let me get this straight. Is it you just get the file like a week in advance, you look at it, and you just show up there and you just help and argue the appeal?
Yeah, you talk to the client. I mean, it's their case. Yeah. So generally, we will show up. If the client's out of custody or is accessible through the institution, if we find a ground of appeal that we think is very viable to argue, we will say to the client, will you let us argue your appeal on your behalf? This is the argument we're planning to raise. And again, we're not amicus. We're not duty counsel, and kind of more like a duty counsel role, just it's the client is self-repped, but we're assisting the court to understand.
Like an amicus, kind of? Or a bit more on the side of the client?
It's a bit more on the side of the client, but it's a very kind of unique role that is just specifically for this appeal kind of program. And sometimes we become quite, adversarial on the client's behalf, but it's only if we feel this is being of assistance. We don't have to assist anyone. And if we find there's no merit to the appeal, we will say to the client, sorry, we just can't help you with this. But at a minimum, we try to give procedural assistance to clients. And a lot of these appeals that are on the self-represented stream are ineffective counsel assistance, right? And we try to be, again, it's the client's decision what they want to do, but we try to be, reality checkers. We try to explain the process. We try to explain the difficulty of how this appeal could play out, help the court understand where the client's going with it, and just generally give some aid to the client up to the point of, if there's a real legitimate issue, we will actually act as almost the client's proxy and step in with their permission and with their authorization and argue the case.
That's actually awesome really laudable stuff, man. Yeah. That's really good.
It's a fantastic. It's a fantastic.
I feel like I feel like if I got in trouble, that's probably the route I'd take.
Don't tell anyone that, because no one will pay for their appeal.
I feel like any time lawyers take on the role either as duty counsel or something akin to duty counsel, they invariably do a fantastic job.
Yeah, for sure.
Even duty counsel, they're legal warriors, man. That's really what they do.
Yeah. Because it's in the trenches work where,
absolutely,
you know, you're not doing it ultimately for, you know, a payday or for like your, you know, but you're doing it because it's giving back, right?
So to that end, what I want to know is when a self-represented person, let's say somebody's in custody, files an appeal. Is it only after they're filing and that they're before the court that they're able to know that this service exists?
Yeah. So we basically, this program was started by Marie Hennen and the late Justice Rosenberg of the Court of Appeal and Allison Wheeler, who's a judge now in Kingston, who's at the Crown's office. It was a collaborative effort between the Crown, the defense, and the court to try to avoid this problem of all these people appearing self-represented. So anytime there's even in the rules of the court, there's a process by which now you can file what's called an inmate appeal. And that's done through the record departments at the jail. So they can fill out these relatively simple forms at the jail. And once an inmate appeal gets launched, the program gets notified and we manage it all the way through. So like anyone who files a self-rep, unless the program decides for whatever reason they're not going to assist, because some clients are like, we don't want your assistance. Like, you know, some clients just want to be non-represented and other clients, you know, won't take our advice and are just not happy with the service we provide. And of course we don't force them to take the service, but they all get at least case managed by the program.
And that's excellent. So I guess in other words, the message is out there in the institution
100%.
Such that nobody is saying, shit, I'm not going to appeal this or I'm going to abandon this appeal because I can't go through this by myself.
Yeah, 100%. They should know that. I mean, again, I think there is an informational deficit in the institution. Like certainly the guards and stuff may not be giving. I mean, I keep hearing over and over again for clients that are thinking about filing appeal, them, you know, either their cellmates or some guard in the jail saying, if you appeal, your sentence will get higher. Like I've been doing this for almost 20 years. I've never seen an appeal where the client has ended up worse off. Like the worst thing that's going to happen, you know, I don't want to say 100% because you can never think of that one instance, but you know, in all of the cases I've ever dealt with, the worst thing that happens is the appeal is lost and you're in the same position you were before you appealed, right?
Unless you're appealing an absolute discharge.
Yeah, or something like that. But like, yeah, I mean, it's you're out maybe the cost and the effort of the appeal, but it's not going to get worse. But you hear that all the time from inmates. They often say, I was told by the jail that if I appealed, it would get worse. The only thing really that an appeal negatively impacts through the jail is if a person is facing parole hearings. Parole hearings are a tricky thing, right? Because the parole board wants to see acknowledgement and contrition. And when you're appealing, except for some really limited circumstances, you generally can't ride both those horses, right? Like if you're the fact that you're appealing shows that you don't have insight necessarily and you're not accepting the verdict and the outcome of the case. And so it can, in some respects, be a negative on parole hearing. So if you're in that short window where like your appeal may not be heard before your parole hearing, maybe that's a cost benefit analysis an accused might have to go through. And I try to explain that to them, but it's very like inconsistent. I mean, I've had clients who have totally maintained their innocence, filed an appeal, lost an appeal, went before the parole board and got early parole. And then I've had other clients that look like great candidates and then the parole officer makes a big kind of deal of the fact that they're appealing and the board says no to them. So, I mean, it's a factor that people have to be aware of, but it's really hard to quantify it. Right?
Mark, when do you sleep? What's that? On this board, that board, appellate work.
I'm busy, but I mean, like one good thing about appeal work is that it kind of is very steady. Right. You know, like, I mean, I see my trial colleagues at my firms where they're in the midst of like a real serious trial and they're working 18-hour days for like 3 straight weeks getting ready for a trial. And, you know, like the workload is not that heavy, but there's also not a lot of downtime. Like you just kind of go from one case to the next case. Right. So it's a steady workload. You have a bit more maybe control over your schedule because you're not in court as much as trial lawyers. So like I'm maybe only in court 2 or 3 days a month, but the lead up to appeals are quite busy and the lead up to like filing deadlines and stuff are quite busy. But otherwise it's wouldn't say it's a 9-to-5 job, but I mean it's still long hours, but it's not as crazy I think as what you guys deal with on the trial side when it's ramping up for trial.
Yeah, but the rush is probably the same when you're in front of the Court of Appeal, right? Yeah. Like I guess I don't know, one of the things I've always wondered is, you know, how I guess you don't feel the pressure anymore? Maybe you do. I don't know. You probably know all the judges by now. You've seen them a dozen times or hundreds of times. You've been in front of them so many times. Do you still get those butterflies in your stomach when you're standing on that podium and you're getting questioned by the
I
judge?
do, but it's like, I guess with anything, as you've been through the trenches a lot, it kind of it becomes more of an asset than a liability.
Absolutely.
Like I feel like I like the adrenaline rush to the first 5 minutes I'm on my feet. But then when the worst thing for me is when the court sits there and doesn't ask any questions and you're just monologuing to the court. Like if you get into a dialogue with me and tell me what your concerns are, I'll try to answer your questions and like we can get into more of just a discussion about this, right? As opposed to me lecturing on why a judge made a mistake or something. To me, those are a much more comfortable hearing. Like when I started off, I was like dreading the questions. I'm like, oh my God, what if they ask me some question I don't know the answer to? And I mean, the bottom line is that happens. Like, no matter how much you prepare, these are smart people and they look at angles that even the parties might not consider. So you might get asked a question that you're just caught flat-footed on. But at the end of the day, like most cases are not won or lost on like a single kind of moment where you can't answer the court's question, right? Like, so I guess once you get over that kind of concern about just being like a deer in the headlights, like I'm stuck here without, and you trust your preparation and how well you've prepared the case and how well you've prepared the argument, generally it's like 5 minutes of butterflies and then it kind of goes away. Now I must say, if you get out of my comfort zone though, like if I go to the Supreme Court the odd time, I don't sleep the night before. Like I just don't. Like it's like the stress is through the roof because again, it's like this is the big show when you're in front of 9 judges and it's like a case that you've been working on for years and years that have wound its way up through the system.
It's the top of the top, man.
Some of whom are grumpy, you know. This is some of whom are grumpy.
Well, yeah, I mean, some of them are not going to be on your side and sometimes you don't even know who's going to be championing your issue and sometimes none of them might see it your way and other times they might all be on side. Like it's just when you put 9 people, 9 very, very like top of the profession legal scholars and judges who have been through everything on a case, you just really never know where the argument's going to go, right?
Separated
that's extremely stressful. But I mean, I guess it's the same with trial, right? Like you never know. At trial it's even more chaotic because a witness could completely drop offside or whatever, right? So
Mark, we know your time is valuable, but I want to end off with a 3-prong question.
3-prong.
What do you think our appellate system does well? What do you think it does poorly? And if there's one thing that if you had the control to change, what would that be?
Okay, so what it does well, 100%, it's very transparent in terms of its judgment production. Like every decision at the Court of Appeal is reported. Where I think it's very inconsistent at the trial level, right? Yeah. Some judgments get reported, some judgments don't get reported. So even from an inmate appeal, self-represented judgment, all the way up to like a first-degree murder appeal or exoneration case, they all get reported. So the judges at least explain their rationale and try to make things. So that's a very like good plus, right? I also think that the focus on like plain writing and plain language and simplifying things at the Court of Appeal, I think like largely across the appellate courts over the last couple decades has been like a very refreshing change. I mean, even the Supreme Court now is doing like plain language judgments where they try to like explain in a 1-pager what the case is about so people can understand it. So I think all of that is like a step in the right direction. What was your second question? Sorry, I forgot the 3 points.
What do you think it does poorly?
Well, I still think there's access to justice issues, and appeals are extremely expensive. Right. I mean, if you have to pay, as the appellant bears the entire cost of the litigation, other than responding to it. Like obviously the taxpayer and the Crown still has a role to play, but unlike trial where like the Crown provides the disclosure, the Crown tells you what witnesses are being called, the appellant bears the cost of all of that on appeal. So they have to pay for the transcripts.
Which can be super expensive if it's a long trial.
Well, yeah, transcripts now, the ministry just passed new guidelines raising, I think, the cost, the non-expedited race of transcripts to $6.30 a page. And this is no slag on the court reporters who have a very diligent job to transcribe all this stuff. Like they need to be fairly compensated. But a week-long trial could be 1,000 pages of transcripts. So even before you get a single hour of lawyer time working on that appeal, a client's out $7,000 or $6,000 plus HST just to pay for the materials to launch like his appeal, right? So it's very cost prohibitive. And unfortunately, appeals are they're most predominantly in writing. So it's very labor intensive. There's a lot of research that has to be done. And if you're paying for legal services, either on a flat fee or by an hourly rate, they can be extremely expensive, right? So, and that in many cases, particularly people who fall through that kind of like income gap, like they're not so marginalized or impoverished that they qualify for legal aid, which is set so ridiculously low, versus people who, are very affluent, who can just shell out the money and just say, here's the whole retainer, I want this done. There's a ton of people who are hardworking people in the middle that just, that can't afford this, right? They don't make enough to pay for the appeal, but they don't make too little to get a government certificate. So I think that is still a key thing that the court has to work with. And I don't know what the solution, if anything, appeals are just getting more complicated as trials get more complicated, right?
So is that the thing that you would change if you could change anything?
Well, maybe other than that. If you could
that's something I guess that doesn't work well. In terms of changing things, they just revamped the court works pretty efficiently, the Court of Appeal. So I don't really have any concerns about the nuts and bolts. Maybe you have to change things again. It's this just picking up this theme of like demystifying things. Most appeals are not, these great works of law that are changing the fabric of the way Canadian criminal law. They're just correcting errors that judges have made and kind of like having better relations with clients, explaining things in plain language, explaining how the process works so people can make informed decisions, just simplifying it so people understand, like, it's not magic what's going on here. Like, you're trying to identify a mistake, explain to the court why that mistake matters, and convince the court that they should do something about it, right? Like that's the task, right? And I think if more people understood that and understood how difficult it is to be successful, it would be more selective in what got up there, right? I think that would be helpful.
Amazing. Yeah. Mark, awesome. It's been an absolute pleasure to have you here.
This has been an absolutely brilliant discussion. I've learned so much. Yeah. Thank you so much for coming in this super shitty weather.
Mark, tell us where people can find you.
So I'm a senior partner at Daniel Brown Law. I'm on Twitter at Halfyard_law. Email, or do you want those details?
Yeah, absolutely.
Yeah, email is halfyard@danielbrownlaw.ca. So that's Daniel like the name, law, Brown like the color, law like law.ca.
Yeah. And they can find you at danielbrownlaw.ca.
Yeah, that's the website as well. Yeah.
I think anyone would be extremely lucky to have you represent them as their appellate lawyer.
I appreciate that, guys. And thank you guys very much for having me. This is the first time
problem.
I've done something like this, and it's been a lot of fun.
Absolute pleasure.
And very special shout out to Chloe. Thank you very much, Chloe, for introducing me to Mark at the last post CLA function. We had a great time. I remember I was speaking with you for a while.
Oh yeah, that's right.
About some of my cases, and you were telling me about some of the ones you're working on.
Yeah, 100%. Thanks for having me. And yeah, Chloe and she was just on that large murder appeal we won. So, Chloe's,
great job.
Chloe's a superstar.
Awesome. She speaks very highly of you as well.
I appreciate
for obvious reasons.
That's good to know.
All right, great. So until next time, thank you very much for listening. Hope you enjoyed the podcast and have a great day.
Thanks guys.
Thank you.